Copyright and intellectual property in digital content creation. Copyright is the exclusive legal right granted to an author or owner to reproduce, publish, sell, or distribute the content and form of a work. This is a crucial legal mechanism, protected by copyright law, designed to ensure that the creative efforts of individuals are respected and exploited fairly. Scope of protection. The scope of works that can be copyrighted is very broad. It includes literary works such as poetry, novels and plays, databases, musical works and songs, websites, paintings, films, architectural works, and even images and computer programs. In other words, most creative products, whether in text, visual, auditory, or software format, can be protected by copyright. The subjects protected are the original creators, the author, musician, programmer, designer, along with their legal heirs. This ensures that the creative value is not limited to the individual but can also be passed on to future generations. Core rights of the author. Regarding the author's rights, there are 3 core points. The author has the full right to decide on the use of the work, from copying and distribution to public disclosure. The author may grant or deny permission for others to use the work. The author has the full right to assign or sell the copyright to other individuals or organizations if desired. In summary, copyright is not just a legal shield protecting the author, but also the foundation for encouraging creativity, because when rights are guaranteed, creators are motivated to continue contributing new values to society. Creative Commons. Creative Commons, or CC for short, is a system of copyright licenses designed to provide greater flexibility for authors, creators, and organizations when they wish to share their works. Unlike traditional copyright, which is often restrictive, CC allows authors to explicitly define the rights that others may use, such as the right to copy, distribute, modify, or even use the work for commercial purposes. Goals of Creative Commons. The goals of Creative Commons can be summarized in 3 points. It creates a balance between protecting the author's rights and encouraging the sharing of knowledge. CC helps the academic, artistic, educational, and technological communities easily access and reuse content legally. It minimizes the risk of copyright infringement due to lack of understanding, which is a common problem in the digital environment. More importantly, Creative Commons contributes to building a culture of knowledge sharing in the digital knowledge society, a place where knowledge is not only protected, but also disseminated and reused to create new value. This is also the foundation that promotes global movements such as open educational resources, OER, and open science, trends that are reshaping how humanity learns, researches, and collaborates. In summary, Creative Commons is not just a set of licenses. It is also a philosophy that encourages the community to share and develop knowledge together, serving the common good of society.
Gemini có thể mắc sai sót, vì vậy, nhớ xác minh câu trả lời của Gemini.
There are 6 common types of Creative Commons licenses, each with different degrees of freedom and restrictions. CC by attribution allows copying, distribution, modification, and commercial use, but requires attribution. This is the most liberal license. CC by SA, attribution share alike, allows modification and commercial use, but derivative works must retain the same license, often referred to as copyleft. CC by ND, attribution no derivatives, allows copying, distribution, and commercial use, but not modification or creation of derivative works. CC by NC, attribution non-commercial, allows copying, distribution, and modification, but only for non-commercial purposes. CC by NCSA, attribution non-commercial share alike, only for non-commercial use, and any derivative works must retain the same license. CC by NCND, attribution non-commercial no derivatives, copying and distribution for non-commercial purposes only, no modifications allowed. This is the most restrictive type. In short, the more NC and ND, the less freedom, while BY always requires attribution. There are many ways to use digital content legally, avoid copyright infringement, and ensure transparency in creation. First, ask for permission and credit. This is the most common way. Contact the author or owner directly to ask for permission, and always clearly state the source when using. For example, before using a photo in a book, we need to ask the author for permission and note source. Nguyen Van A. 2020. Second, comply with open licenses. If the content is attached to licenses such as Creative Commons or GPL, users only need to follow the prescribed conditions. BY, NC, SA, or ND. For example, when using music with a CC by SA license in a teaching video, we must credit the author. Third, fair use. The law allows quoting a small part of the content for research, teaching, commentary, or journalism, as long as it does not affect commercial interests. For example, quote 2 to 3 lines of poetry from the lecture for analysis. Fourth, exploit public domain content. These are works whose copyright has expired, usually 50 to 70 years after the author's death, and can be used freely. For example, Shakespeare plays or Mozart music. Fifth, buy the right to use. In many cases, users need to pay a fee to use them legally, especially for commercial purposes. For example, buy photos from Shutterstock to print event posters. Sixth, create your own or use internal sources. This is the safest way. Create new content yourself, or use documents that the organization has purchased copyright. For example, design your own infographic or use a textbook that has been purchased by the school. In short, using content legally can come from asking for permission, complying with the license, citing appropriately, taking advantage of the public domain, buying copyright, or creating it yourself. Each helps us create and learn while respecting copyright. Solutions for protecting intellectual property in the digital environment. To protect intellectual property, IP, rights in the digital environment, we need a synchronized combination of measures, not only legal but also technological, managerial, and educational. This not only assures creators, allowing them to focus on creativity, but also establishes a transparent and sustainable digital ecosystem. Among these, the two most important groups of solutions are legal and technological. 1. Legal measures. The legal group focuses on copyright registration, signing contracts or licenses such as Creative Commons, and implementing enforcement actions when infringement occurs. The greatest advantage is the clear legal value, ease of proving ownership, and strong deterrent effect. Simultaneously, this helps build the credibility of the author and the organization. However, legal procedures can be complex, costly, and their effect is often limited to national borders or international agreements. Typical examples include copyright registration at the Copyright Office, using assignment contracts, or sending a notice and takedown on platforms like YouTube to remove infringing content. 2. Technological measures. The technological group directly protects the work within the digital environment. Common measures include DRM, digital rights management, in ebooks, watermarks and metadata embedded in images, or digital signatures for documents. Recently, blockchain and NFTs have also been applied to certify ownership of digital works. The advantage of the technological group is strong protection, difficulty in counterfeiting, and flexibility for sectors such as e-commerce, publishing, and digital art. However, it also has limitations. It can sometimes cause inconvenience for legal users, technological costs are high, and some new solutions like blockchain or NFTs are not yet globally mainstream. For example, ebooks with DRM prevent copying, photos with watermarked logos, or an NFT certifying ownership of a digital art piece. In conclusion, legal and technological measures are two parallel arms in IP protection. The legal side ensures deterrence and affirms rights, while the technological side provides direct and immediate protection. Combining both is the key to creating a digital environment that is safe, fair, and supportive of long-term creativity.